So welcome. Thank you for coming along to Data Protection Made Easy, which already I regret. We've also promised some fun, which again, already I regret. I've actually got the royal story today, so my bit's fun. On the other hand, Ian's got the extremely topical Lloyd and Google story. So you have come at a really great time to learn all about this and hear all about Lloyd and Google. And we've already had a question kicking us off about Lloyd's. We will deal with that later when we come to it, if that's okay. So yeah, nothing could be more topical at the moment than this, both in relation to Meghan Markle being in the news and in relation to Google being in the news. So we will canter through. The way we are going to deal with it and structure it today is that I'm going to deal with the mechanics of it, the mechanics of the Data Protection Act, and the really slightly less fun parts of it. Ian's going to deal with the rip-roaringly fun remedies aspect of things. So Ian's really got the long straw here. I've got a really short straw. I know that we've got quite a lot of people from local authorities and quite a lot of people from the police and people who advise them. We should just say at the beginning, and I'll make it clear as we go through, that law enforcement agencies, as you know, are subject to a different regime, although it's similar. So everything that we say is caveated by that some of the things that we're saying will not be relevant to you, and there will also be additional principles for you to apply in your particular situation. The same thing is true of national security, although we haven't got anyone who's identified themselves as a spy attending today. Although they wouldn't, would they?
They wouldn't, of course.
No. But if you would like us to give a talk, if there's any interest in us giving a talk on law enforcement agencies specifically, then we will be delighted to do that for you. And indeed spies, if there are any spies here attending who haven't identified themselves. So without further ado, let's have a quick canter through the principles. And first question to ask yourself is, well, what is the cause of action here? There's two main causes of actions that we're going to look at today. The first is misuse of private information, and really the only reason we're looking at this is so that I could stick a picture of Prince Harry and the Duchess of Sussex on there. This is the context against which we've just heard the shocking news that Meghan forgot that she had had conversations about this letter to her father, which we've all been seeing in the news in recent days. And why is that important? Well, one of the reasons she's suing associated newspapers, i.e. the Mail, is for the tort of misuse of private information. And the relevance of her forgetting that she was talking about whether or not it might be leaked, the relevance of her seeming to have drafted this letter with half an eye on it being leaked, is twofold. If you're going to sue in the tort of misuse of private information, the information's got to be private and there's got to be a reasonable expectation of privacy. So if you send your dad a letter that you don't anticipate is going to be leaked, or that you're not drafting with half an eye on it being leaked, then that information is private and you have a reasonable expectation that that letter just goes to your dad and it stays there. In this particular case, though, and it's a bit of a shocker because it's only come to light in the Court of Appeal, it looks as if the information may not have been private because she may have been drafting it for a wider audience, and there may not have been a reasonable expectation of privacy because she's been talking about whether or not it would be leaked and making sure that if it was leaked, that that wasn't something that could come back to her. So she's suing for the tort of misuse of private information in circumstances in which the information may not be private, and there may not have been a reasonable expectation of privacy. You'll recall that in the High Court, the court gave summary judgment in her favour for that. We're now up in the Court of Appeal and new evidence has come to light, which seems to suggest, I think, don't want to second guess the Court of Appeal, wouldn't dream of it. But if I were in the Court of Appeal, I would be saying, well, hang on, this is something that needs to be tested now because we've got some doubt now as to whether or not that information was private and whether or not there was a reasonable expectation of privacy. So the tort may not be made out on what we now know. The good news for claimants about the tort of misuse of private information is that it's a strict liability tort. You don't need to prove fault and you don't need to prove proof of loss. And that's going to become more important when we come on to Ian's part about remedies. But the bad news about the tort of misuse of private information is that there is a defence of freedom of expression. So we've got these two rights that are in tension with each other effectively. I've got a right to privacy, Ian's got a right to freedom of expression. So if I send Ian a rude letter about somebody else, he's got a right to tell everyone about that because of his right of freedom of expression, but I've got a right to privacy because I wrote that letter. And so there is as I say, a tension, a balancing act to be performed between his right of freedom of expression and my right to privacy. And of course, the way that we often see that playing out, usually see that playing out, is where you've got public figures on the one hand who've got a right to privacy, and you've got newspapers on the other hand who've got a right to freedom of expression, and you get very po-faced comments from the media saying, well, you know, the public has a right to know all about X and Y. And public figures, we know, have to bear a level of intrusion that other people wouldn't necessarily tolerate because they've put themselves in the limelight. But even the public figures have rights. Even royals are humans too. So they do have some right to privacy. It's just a question of balancing that right against the newspaper's freedom of expression. We saw it recently in the Duke of Edinburgh will. Well, Nick says scandal. It's not a scandal at all. When the Duke of Edinburgh died, his will was not made public, and that doesn't tend to happen, hasn't happened in relation to royals. Their wills are never made public for 50 years unless they choose to do so. And the newspapers were unhappy about that because they said, well, we've got a right to publish this because it's in the public interest of people to know who the Duke of Edinburgh left his money to. And the court said, well, yeah, you don't. The public have no interest in knowing that. It's not important to anyone else. It's a matter for him. So it's effectively a balancing act. And the intrusion on the right to privacy has to be necessary and proportionate. So there's got to be some good reason as to why the press are publicising whatever it is that they're publicising. So that's the tort of misuse of private information. It is a balancing act, it's strict liability, but you don't need to prove loss. And what you often see with these cases is misuse of private information being brought as a cause of action alongside breach of the Data Protection Act, which was the Data Protection Act 1998, and is now Data Protection Act 2018. And that sets out the framework for domestic data protection law. And you'll see there the usual slide that has to do with Brexit, that it was amended as a consequence of our withdrawal, but it remains in force, and that there are now new regulations as of 1st January 2021, which sit alongside the Data Protection Act. So what's fun about data protection is that you have a number of different causes of action, a number of different legal frameworks sitting alongside each other and in parallel with each other. And it's impossible to read the Data Protection Act if you don't do it alongside the regulations because they inform the Act. Bear in mind that all of this comes from Euro legislation. And the underlying directive which gave rise to this legislation was effectively the EU saying the right to privacy is a fundamental human right, and this is what we need to do to protect it. So they've gone from very, very big picture, this is a fundamental human right, to very, very small granular, this is what we have to do to protect it in the regulations. So you need to be reading both together. So part 2 of the DPA deals with general processing, sits alongside the GDPR, and also sits alongside if you're looking at advising the police or you're advising in a matter which arises out of law enforcement, you're looking at part 3. So if you are looking at data protection in that context, in a law enforcement context, you are looking not just at part 2 of the Data Protection Act and not just at the GDPR, but you're also looking at part 3 and various other schedules. So that is very much more complicated, and we're not going to go into those details and the way in which they're different. Suffice to say that in relation to law enforcement, there are some really, really strict rules about how the police deal with your data, because obviously the data that the police have are very much more sensitive than the data than, let us say, Google has. And we're looking at things like profiling. So when the police are profiling, one of the very sensitive issues around profiling for gangs is how they profile with gang members against things like race and location. And all of that is perfectly justifiable if you're in law enforcement, because it's really important to get an idea as to where the gangs are and what their makeup is. But it is also extremely sensitive. So it has to be done in a really sensitive way. And there are particular rules about profiling, and there are particular rules about particularly sensitive information. You also find with law enforcement that there is a very, there are very graded, compartmentalized categories of information. So if you are a suspect, or if you are a victim, or if you are a witness, or if you are a convicted person, those are different compartments that you will sit in. And you may be taken from one compartment to another. You may go from suspect to convict, or you may go from witness to suspect, for example. And there are very particular rules about taking you out of one box and putting you into another. So there are particular rules around law enforcement, and the same with national security and defence. Now, I'm not going to deal with those rules today, apart from the very swift overview that I've just given. So we're just going to look at the general rules for dealing with GDPR that we're all ought to be familiar with by now. And particularly, we need to think about that both in the context of bringing GDPR claims and defending these claims, but also in the context of what are we doing, because we come into contact with lots of sensitive information all the time. And, you know, there was a time when I first came to the bar 1,000 years ago when you just had boxes and boxes of people's medical records, and they spilled out into the corridor. They were all over people's floors. I remember one particular member of Chambers who'd been around for quite a long time used to cross-pollinate his briefs. So one would sit in one corner of the room, the other would sit in the other corner of the room, and they would kind of creep over. And then they would get all mixed up, and there would be sort of 4 different piles of medical records all mixed up with each other. That's generally not now regarded as being a great idea. I'm not sure it ever was a great idea, but it's just not permissible now. For a start, they've got to be filed in a particular way, but secondly, they've got to be secure. So let's look at the provisions under the Act and the regulations, and have a look at what we're allowed to do and how we're allowed to do it, because those are the 2 questions that we're asking ourselves. The GDPR that came into force on the 1st of January 2021 sets out the granular, how are we allowed to do this? Doesn't deal with law enforcement or intelligence agencies. The reason that law enforcement and intelligence agencies are taken out of the generalised principles is historical. So effectively, it's because there were 2 different directives from the EU. One dealt with data controllers and processors generally, the other dealt with law enforcement and so on. And so that's why they've historically been entirely separate, although the Act does try to, it has part 1 or whatever, part 2 that deals with general GDPR, and then you've got part 3 dealing with law enforcement, and then part 4 dealing with national security. So what are the general principles under the Act and the regulations? Because as I say, they both refer to each other. The Act refers to the regulations. So personal data should be processed lawfully, fairly, and in a transparent manner. And effectively what that means is the way that a person, a reasonable person, would reasonably expect you to be processing their data. So there are certain things that people would expect you to do. So if you give your data over for the purposes, let's say, of making a legal claim, and let's say you've given your consent for it to be used in a particular way, you do not then expect your solicitor to use it in a completely different way. So an example that's given by the ICO is, well, giving it to somebody else, giving it to a third party so that they can then use it to cold call the person. So if you go to a solicitor and you give your data to them for the particular purpose of bringing a claim, you don't then expect to be cold called 2 weeks later by the solicitor's husband who runs a travel agency. This is the example given, who is saying, well, I understand that you go on holiday to these particular cases, to these particular places. It's got to be collected for specified, explicit and legitimate purposes, and not further processed in a manner incompatible with those purposes. And effectively what that's saying is, I give my information to you, you use it for the purpose that is first allowed. Now you can change the way you use information or the purpose that you use it for, but you have to make that clear to the person whose information it is. So personal data needs to be used in a thoughtful way. You don't just spread it around all over the place. You use it for the way that it's been authorized from the off. Personal data should be adequate, relevant, and limited to what's necessary in relation to the purposes for which they're processed. And so you see that it's really important to look at the purposes from the very beginning, because then you can look at whether or not the information that you've got is adequate, relevant, and limited to what's necessary. It's got to be accurate and kept up to date if necessary. And every reasonable step has to be taken to ensure that where it is inaccurate, it's erased or rectified without delay. And effectively what this is saying is when you have someone's data over quite a long period of time, and it may be that it becomes inaccurate, you need to take steps to keep that data up to date. And I'm thinking of things like addresses, medical conditions, and things like that. Addresses is the one that springs to mind, that you need to keep on ensuring that the data you've got is accurate. And when it becomes inaccurate, you need to get rid of it. Now, the processing principles are the ones that give rise to some difficulty. So personal data should be kept in a form which permits identification of data subjects for no longer than is necessary for these purposes. So as soon as you don't need that data anymore, you need to archive it. And archiving in itself is a process, but that's fine because it comes within an exemption. So you need to be sure that you're not keeping it for a purpose that isn't authorized, and you're keeping it for no longer than necessary. You've then got to process it in a manner that ensures appropriate security. So things like leaving bags full of medical records on the train, which is a thing that every barrister has done. I don't believe anyone who says they haven't. Doing things like that are breaches of the Data Protection Act, obviously, because it's not appropriately secure. I'm thinking about things like encryption. If you can anonymize, then that means that it won't be personal data at all because it's not identifiable to an individual. But pseudonymizing, really pleased I got away with that. Pseudonymizing is another way that ensures security for the data if you can pseudonymize something. Encryption and so on. And encryption is really, really important. Obviously, everyone is thinking about hacking at the moment. And so we're talking about physical security as well as virtual security there. And there should be a protection against unauthorized or unlawful processing, against accidental loss, destruction or damage, and you use appropriate technical or organizational measures. And quite a lot of what this is about is to do with showing that you have thought about this, showing that you've thought about the integrity of the data that you're handling, and that you've considered and you've got a policy about dealing with it, and you've asked your IT people to advise you about how to keep this data safe, particularly now when there's a lot of hacking going on. And the Act is, of course, underpinned as it is by this thinking about fundamental rights, it's underpinned by Article 8 of the European Convention. So when we look at how to interpret the Act, we're looking at the right to privacy, we're thinking about how the subject, the data subject, is going to be thinking about their information being used by you. So it's a consumer piece of legislation again, so we need to look at it from that point of view. Now, you can process information only if it's lawful to do so, and it will be lawful if you fall within one of these categories. Now, no one of them is better than any other. Consent is easy because you just get the consent of the data subject to process. But if the data subject has entered into a contract with you and it's necessary to process their data in order to satisfy that contract, that's just as good. So, for example, if an example given by the ICO is where a consumer asks for an insurance quote for house insurance, you need to process their data as an insurance company in order to provide that quote. Now, they might not have explicitly consented to you using that data, but the request that they have made implicitly consents because of the contract makes it necessary in order to process their data. There may be some legal obligation on you. I'm thinking of money laundering legislation, that's the obvious one, where somebody may not consent to you providing their details to the authorities, but where you have to do it because of the money laundering obligations. Now, that's fine, you do that, that's no problem. If there is some vital interest, both of the data subject or of somebody else, So this is, for example, information given to you confidentially. We all know that where there is that information impinges on the safety of a child, for example, you have to hand it on to the proper authorities. And that is, of course, a lawful purpose for dealing with that data. If you are lawfully carrying out a public task, so for example, you might be a university, you need to process people's information in order to offer them places, in order to consider what needs you have for running courses, that's fine. That's another lawful purpose or some legitimate interest. Now, there is a special category of personal data, and this processing of this data is prohibited. So this is personal data revealing racial or ethnic origin, political opinions, religious philosophical beliefs. We've been looking a lot at things like how people feel about trans rights, how people feel about the word women. These beliefs can be philosophical beliefs. So information about that, philosophical belief, so it falls into special category data. Trade union membership, genetic data, biometric data, and thinking about the police, obviously that comes in there. And processing that data is prohibited unless you can show that you fall within one of these categories. So the person is explicitly consented to you processing that particular special category data, where you're processing it for the purpose of employment and social security law, so you're a government agency effectively. If you're protecting another data subject, so again, we see this again and again, where you're looking at protecting somebody else. Membership of a not-for-profit organisation, we're talking about things like trade unions, charities and so on. It's lawful for them to process information about their members to do with things like political beliefs, because that is of the nature of the thing that they're looking at. Data has already been made public by the subject, so there's no harm in you making it public or processing it in some other way. Legal claims. So this means that when we are provided with special category data by our clients, we can process that data for the purposes of making a claim or defending a claim made by that person. So things like medical records and so on, or if you're in an employment tribunal, things like beliefs, you can process that information because it's important to do it, it's necessary to do it, it's proportionate to do it within the context of the legal claim. But you need to ask yourself, do I need to put this client's medical records, all of their medical records in the trial bundle, or can I just put some of them in and redact parts? So is it necessary and proportionate to provide all of them or just some of them? If you're looking at preventative or occupational medicine, and then there's another one at cross-border medicine, which is particularly pertinent at the moment. So if you're processing the data for purposes of preventing a huge pandemic, then that is a lawful reason to do it. And archiving, of course. So if the data, for example, becomes inaccurate and you want to archive it, that's a perfectly reasonable thing to do in processing. So when you are looking at processing this special category data, you've got to show the lawfulness under Article 6 that we talked about before, that you have to do in the generalized principles, but also additional and associated requirements. And you will need to have appropriate policy documents in place, and there will be professional duties of confidence. And in addition to all of that, in addition to these particular categories that you've got to bring yourself within, it's also got to be always fair and transparent in the way that we've spoken about. So the data subject would reasonably expect that processing to be conducted in the way that it has been. So where, for example, I've given my consent for you to use my data in a particular way, and you use it in a different way, that might be lawful. You might have a lawful reason for doing that under one of these lawful reasons. But it wouldn't be fair and transparent if I haven't consented to it being used for that purpose. So where the first reason you're able to process data is consent, you will always need to go back and get consent for any further reason for processing. And of course, subjects must be provided with all information necessary for them to understand what's going to happen to their data. And there's a tension here in the Act, and there's no getting away from it. There's a tension between provide the data subject with all information about what you're going to do, provide it in reasonable language, in understandable English, and provided in a way that is really transparent and obvious. So you need to provide your data subjects with information about what you're going to do with their data, but don't overwhelm them with information about that. And that's actually quite difficult. Now, let's look. Why is data made public by the subject provided as a reason for processing special category data, but not a reason to process normal personal data? I don't know the answer to that. It's peculiar, isn't it? I would have thought that it would be a good reason to process not special category data. So let's have a look at Article 6 and see if we can think about that. Yeah, I mean, it wouldn't fall within any of those, would it? So I don't know the answer to that. I don't know the answer to that. But so it is. All we need to know is that is what it is. We don't need to know the rationale. Well, we may like to know it, but we don't know. Now, remedies. Tom, I can see you raising a hand, but there's nothing I can do about that. So just tell me in the chat what it is that you want to ask, or if you've got a question, then please ask it. But I can't do anything about if you raise your hand. I will mute myself now, having cantered through that, and Ian will tell you a little bit about remedies.
Thank you, Sarah. I should just say for clarity that for those people at police forces who advise police forces are still bound by the UK GDPR and Part 2 of the 2018 Act for non-law enforcement processing, so dealing with employees' data, occupational health, things like that. That is still general processing, so you still need to be looking at things that Sarah's just gone through so well. And the law enforcement section is a very specific aspect when you are using your policing function. So with that throat clearing for our police colleagues, we are bang up to date on Chancery Lane. Day after Lloyd and Google, there's already something on the blog, and we will be talking about it, or I'll be talking about it. Short, but before we get to Lloyd and Google, it's as well, we think, to have a little bit of a history lesson and look at the Section 13 of the Data Protection Act 98. It's relevant because it informs so much of the way we think about damages claims in data protection litigation now, but of course it's still being litigated. Claims are still being litigated under the 98 Act, so you do need to have a sense and a feel for what's gone on. And the starting point for current purposes is Section 13, the slides there, and it provided that perfectly straightforward. A person who suffers damage can get compensation. Well, that's straightforward. And you can only get compensation for distress, so I'm a bit upset about all this, if either there's damage, so financial damage, or there's the contravention in question relates to processing for a special purpose, which is sort of journalistic purposes and things like that. So in essence, there's a problem. If there's a breach, you can get compensation if there's financial damage, and you can get some compensation if you're upset by it, but only if there's some damage as well. Can we have the next slide, please? That understanding of Section 13 was adopted in obiter comments by Lord Justice Buxton in a 2007 case called Johnson and Medical Defence Union. And he said in that case, there's no compelling reason to think that damage in the directive has to go beyond its root meaning of pecuniary loss. So damage under Section 13, it is what you think it is, it's pecuniary loss. But then you get Murray and Express newspapers, or sometimes known as Big Pictures. And that case, well, you may remember it, it was the newspaper took photos of J.K. Rowling and her family, and she was very upset by all this. And it found its way to the High Court. And the court says, well, hang on a minute. If you read the Data Protection Directive, it's at least arguable that it warrants a construction of Section 13 that would allow recovery to injury to feelings. It's at least arguable, says the court in Murray, without actually making any findings on the issue. So the court's starting to open up, or there seems to be an indication that there's a desire to reopen how Section 13 should be interpreted. And again, as Sarah says, what you're trying to do, or what the court says you were trying to do, is vindicate privacy rights. And in order to do that, if we can have the next slide, you get cases like Halliday and Creation Consumer Finance from 2003. Now, the claimant in Halliday can't prove any financial loss. Never going to do it in a month of Sundays. But the court still wants to give the claimant some money. So what they do is say, we'll tell you what, you can have nominal damages, you can have £1. There you go, there's your £1, that's nominal damages. What does that mean? Well, you've got damage now, don't you? So because you've got damage, you can now have some compensation for distress for the purpose of section 13.2. And of course, this is a complete fiction, Halliday. And if we go into, it winds its way through the courts. And the year after Halliday, there's a case called AB, Ministry of Justice. And the claimant there proves distress. And the court values that distress at something like £2,250. But there's no financial loss. So poor old AB is on a hiding to nothing. But the court goes, no, well, this poor claimant has spent ever so long trying to obtain disclosure from the horrible defendants. You're sure you're entitled to some sort of damages for that. There's another £1, as they did in Halliday. Happy days for the claimant. He gets his £1, he gets £2,250, and his solicitors get their costs. And this is recognised as complete fiction to an extent in the next slide, in case we see the next slide. Sorry, Sarah's in charge of the slides. I'm not allowed to look after these things. Vidal Hall. In Vidal Hall, the court says Halliday is being used as a gateway for an award of substantial compensation for distress. And everyone recognises this as a complete fiction, and it is a far from satisfactory state of affairs. Vidal Hall, again, Google in the fire line, it was all about browser-generated information collected via the Apple Safari browser without anyone's knowledge or consent. And it's common ground between the parties in this case that if you read section 13 of the DPA 98 and give it its natural and literal meaning, the claimants can't succeed because there's no pecuniary loss. So what do you do as the claimant in this situation? Well, you look at the underlying EU directive, and the court says, well, given it its natural, you can give it a natural and wide meaning of Article 23 of the directive. That can include both material and non-material damage. And the court says, and again, this is something that Sarah was talking about, it seems to me, that what the purpose of the directive is the protection of privacy rights. It's not the protection of economic rights. And once you appreciate it's a creature of Article 8, you're trying to vindicate the claimant's privacy rights, then it is odd to limit the meaning of damage or the definition of damage to financial damage. It can encompass and should encompass, says Vidal Hall, distress. So what the court says is what is required in order to make section 13.2 compatible with EU law is the disapplication of section 13.2, no more and no less. The consequence of this will be that compensation will be recoverable under section 13.1 for any damage suffered as a result of a contravention by a data controller of any requirements of the Act. So you're up and running as a claimant. You can get compensation if you're a bit upset. Next slide, please. No, you've got a bit too far ahead. It should be TLT. There we go. TLT. Worth a read, TLT, not least in terms of understanding quantum, because there's a very good analysis of the awards given to various claimants. It's a case about the Home Office accidentally disclosed a spreadsheet that contained details of applicants involved in the family returns process. Now, the spreadsheet was anonymized in the sense that people were given acronyms, but you could work out, if you wanted, how to identify the individuals. But there is an argument run by the Home Office, by Oliver Sanders, I think, for the Home Office. And they say, well, there's got to be some sort of threshold before you can get damages for distress. And Mr. Justice Mitting says, yes, you're right. Of course there's a threshold. I agree there is. It's the de minimis principle. There is no other. So if you can prove on the face of it de minimis, a de minimis amount of upset, you're up and running with the damages claim. And that should take us, I hope, on to the next slide, which is about Rolf. And again, I said we're bang up to date at 1 Chancery Lane. This is a decision that only came out a couple of weeks ago. We've already written about it, and here we are talking about it again. Rolf and Bill Wansborough. This is a sort of claim that can happen to any organisation in the 21st century. What happens, in essence, is that Bill Wansborough wants to send an email with a letter attached to the claimant. Somebody types it all out, puts in the email address, gets one letter wrong or a character wrong, and off it goes. The recipient, who is not Mr. and Mrs. Rolf, emails back saying, terribly interesting, but nothing to do with me, Gov. Bill Wansborough email back and say, oh, terribly sorry, can you delete the email? And the recipient says, yes, of course, already done it. And the claimants then sue Bill Wansborough. And it's worth, I just see someone saying, oh God, sorry, I must have meant on the key, but I hope he didn't send an email to someone by mistake. But anyway, Master McLeod says it's common ground that in principle damages can be recovered and other revenues obtained for breaches of data protection regulations and misuse of private information, including simply for the distress caused, even absent specifically pecuniary loss. So that's Vidal Hall. So you're distressed. Here's some money. Similarly, it is not in dispute that in principle loss of control of personal data can constitute damage. Lloyd and Google, well, that's the Court of Appeal, more of which in a second. Move the next slide, please. But hang on a minute, says the Master. Look at what Sir Geoffrey Voss says in Lloyd. I understood it to be common ground, says Sir Geoffrey, that the threshold of seriousness applied to Section 13 as much as to MPI, misuse of private information. So pausing there, there's a threshold of seriousness before you get going in Section 13 for the DPA 98 and in misuse of private information cases. And Sir Geoffrey goes on, that threshold would undoubtedly exclude, for example, a claim for damages for an accidental one-off data breach that was quickly remedied. So next slide, where does that take us to? Next case of Coward, we'll look at Coward, 2011 case, where the court says just because information relates to a person's family and private life, it will not automatically be protected by the courts. For instance, the information may be of slight significance, generally expressed or anodyne in nature, while respect for family and private life is of fundamental importance. It seems to me that the court should, in the absence of special facts, generally expect people to adopt a reasonably robust and realistic approach to living in the 21st century, which is a bit of a we'll grow up and get on with it observation, I think. And if we go on to the next slide, where this takes us is that the Master concludes, in this case, the question boils down to the relatively simple one. Given the nature of the breach and the nature of the information and the steps taken to mitigate the breach, and the material before me, is it more than fanciful to suppose that either that actual loss has been suffered or that distress has been suffered above a de minimis level? Next slide. The Master goes on, we have a plainly exaggerated claim for time spent by the claimants dealing with the case and a frankly inherently implausible suggestion that the minimal breach caused significant distress and worry or even made them feel ill. In my judgment, no person of ordinary fortitude would reasonably suffer the distress claimed arising in these circumstances in the 21st century in a case where a single breach was quickly remedied. And she goes on, there's no credible case that distress or damage over de minimis threshold has been proved. And it's important, this, I think. In the modern world, it is not appropriate for a party to claim, especially in the High Court, for breaches of this sort, which are frankly trivial. So we have the court saying, well, the threshold is de minimis, but you have to take a reasonably robust and objective analysis of whether anybody can really claim to have been distressed, upset in the circumstances of this type of data breach, where, yes, there's a data breach, but it was quickly remedied, and nobody reasonable fortitude in the 21st century could realistically and sensibly say they were upset. So the claim fails. It was there was permission to appeal sought, and that was stayed pending Lloyd and Google, which we come on to now, I think. Hot off the press, Lloyd and Google, only yesterday. It's important to have some sense of what was going on in this case, because it's a bit long-winded and it is a bit complicated. Mr. Lloyd is a consumer rights activist and had previously worked for Which. And he alleged that Google breached the data rights of 4 million people who had Apple phones between 2011 and 2012. And Mr. Lloyd appointed himself the representative of all these 4 million people and said, well, I'm going to go off and sue Google. And the damages were up to, they calculate, up to £3 billion. So it gives you the idea of the scale of the potential. And that's only 750 quid each. 4 million people gets you to 3 billion or thereabouts. The legal costs were estimated to be getting on to for £30 million as well. So it is a hell of a lot of money everyone's talking about. But to get going as the representative of these 4 million people, Mr. Lloyd needs to show that he's got the same interest in the claim as everyone else. Now that's difficult because he plainly doesn't have the same financial losses, or indeed most of the people don't have any financial losses given the nature of the breach. So he doesn't have the same interest there. And he can't say he's got the same interest in the level of distress that everybody was suffered, because you'd think about 3.99 million of the 4 million people either don't know about it, don't care about it, or don't think about it at all. And whereas you have Mr. Lloyd, who's clearly very upset about all of this, and you would have thought that somewhere in the middle there's people who are a bit bothered, but in the grand scheme of things, just need to go shopping and pick the kids up. So how do you get around this need to show that there is the same interest before you can bring your representative action and proceedings outside of the jurisdiction? Well, says the claimant, we know that in misuse of private information cases, you can claim damages for loss of control of data, of the information. We can do that here. We all have the same interest because we lost control of the data. We can recover damages for that. So off we go. And in our first instance, the court said, no, you don't. What a load of rubbish. Court of Appeal says, no, that's not rubbish, that's right. Of course you can, off you go. And the Supreme Court yesterday says, well, no, sorry, that's wrong, because you have to look at the wording of section 13.1, which we did at the start, because this is a case brought under the 98 Act. Although I don't think that makes a difference, a material difference for claims under the 2018 Act. And the court says, if you read 13.1, those words can't reasonably be interpreted as giving an individual right to compensation without proof of material damage or distress. So you need to prove material damage, you need to prove distress to bring the claim. And just couching the damage as loss of data doesn't do it, because what that is, what you're saying is, it's just another way of saying there's the contravention of the Act. The loss of the data is the contravention of the Act. That's not the damage. You need the contravention of the Act that causes the damage. And that damage, the Supreme Court says yesterday, has to be material damage, so financial damage, a loss of some sort like that, or it can be distress. But just loss of data, loss of control of the data, in the sole context of data protection litigation, does not give rise to a freestanding claim. And that's the importance of Lloyd and Google, in part. It's important because Sarah, it's almost like we think about this. Sarah started off by talking about misuse of private information. It's important to realise that Lloyd and Google does not alter the fact that loss of control can be claimed in misuse of private information cases. And so that argument is still alive and kicking, but not in data protection. The consequences of Lloyd and Google, we'll start off with the claim ends, and it's also worth noting that there were representative actions against TikTok, Facebook and Marriott that were waiting to go forward after Lloyd and Google, and it seems unlikely that they will now go forward. It also seems to me that this will reduce the pool of claimants generally in data protection claims, because those claimants who really have a very low level argument about distress and previously could have said, well, there's loss of control, so I can get home on that. They go by the wayside, I think. And thirdly, it is arguable, at least, and I would argue that the effect of Lloyd is that it should depress the award for claimants generally, successful claimants, because what tended to happen in damages claims or damages awards was that the claimant receives damages for the distress and the loss of control, and it's all rolled into one award, so £2,000, £3,000, £5,000. So if you're taking out half of the rationale of the award, then arguably there should be a depressing effect on the award of general damages generally. And if we go on to the next slide, very quick slide about defences. I'm not sure whether I'm meant to be dealing with this or Sarah, but there you go. In the 1998 Act, section 13.3, there's a defence that's not transposed into the 2018 Act or the GDPR. But now I will mute myself again. I think Sarah's got some closing remarks, if I can work out how to mute myself at the moment.
Yeah, no, we had a couple of questions, so I don't feel you should mute yourself here, and I might need you to help me with them. There's been a question about do we need medical reports in every case? Now, for my own part, I don't think you do. No, you don't. Because
this is the head scratcher for common law lawyers, negligence lawyers, PI lawyers. You get compensation for distress. You don't have to show a recognised psychiatric illness. You don't have to say you're depressed or you've got an adjustment disorder. It's not like negligence, and there's lots of cases. Well, it's not lots of cases. There are some cases about this where claimants try to suggest there's a negligence claim as well, and the court routinely says, well, no, there's no duty of care, common law duty of care, because you have the DPA is the framework. That's where you go to. But one of the other problems is not just that there's no duty of care, but distress in common law negligence is not actionable. So no, claimants don't need a medical report to get going. They just need to show more than de minimis distress. That is not to say that you do not get cases where there are medical reports, and I certainly have several cases where claimants have either suffered, or they say they have suffered, either PTSD or exacerbations. I don't know why Sarah's smiling, but I say they have, or say they have exacerbated. They say they've had an exacerbation of their PTSD as a result of data breach, and they have a psychiatrist report, a psychologist report in the normal way. But you don't need it to get off the ground, if that answers the question.
So if it's just distress, no medical report, if they're claiming for chunkier damages for a recognised psychiatric condition, it's medical reports in the usual way.
Yeah.
Which protocol should the claimant use? And again, I think that depends on what you're claiming for, doesn't it? If you're claiming for personal injury, then it's personal injury.
Well, I'm not sure you do, actually, because is the pre-action protocol for media and communication claims, and that is the protocol for if you look at it, it says pre-action protocol was updated from a consultation when the media and communication list was founded in 2017. It now applies to cases within the scope of 53.1, all cases involving claims in defamation, misuse of private information, data protection law, or harassment by publication, claims in breach of confidence, malicious falsehood, and so forth. So data protection law, I would say, don't hold me to it, I would say it's the pre-action protocol for media and communication claims.
Okay, great. And then we've got some questions. Has Lloyd restricted misuse of private information to only deliberate acts as opposed to accidental publications? Well, Lloyd actually has nothing to say about misuse of private information, because in Lloyd, don't forget, Mr. Lloyd was trying to bring this representative action. And in order to do that, he wasn't able to, and he didn't, bring a claim in misuse of private information, because he said he was acting on behalf of these 4 billion people, and he couldn't show either the information was private, but more pertinently, that all of those 4 billion people had a reasonable expectation that it wouldn't be published. So, or that was theoretically why, that was the theory as to why they didn't bring the claim of misuse of private information. But he didn't bring a claim of misuse of private information. So Lloyd isn't about misuse of private information.
It's not. Lloyd does talk about misuse of private information.
Yeah, it does.
In the sense that the court says you can get home on a claim of loss of control of your information in an MPI claim, but you can't in the Data Protection Act claim. And the reason for that, the court says, is by its very nature, if you're talking about an MPI claim, there is a reasonable expectation of privacy that the information is private, and in those circumstances it would be right to allow a claimant to succeed on a suggestion that they've lost control of that very private information. Data protection, and this is one of the reasons why Lloyd is important, because it seems to be rolling back a bit from the suggestion that data protection is all about privacy, because the court says, well, we're not really talking about private information here necessarily. So this idea of the loss of control doesn't get you home, but it is interesting, because it seems to me that if sort of low-level cases are going to keep being litigated as they have been since Lloyd in the Court of Appeal, certainly, then claimants, I think, are going to start looking more at MPI and trying to suggest that there's a reasonable expectation of privacy. But we will see. I mean, I do wonder whether Lloyd, in some respects, is really going to kill off a lot of the low-level data protection claims, in combination with cases like Rolf, where you see courts being. I get the sense from cases I have done and from judgments you read that there is a bit of an alarm, certainly in the High Court, about the amount of low-level litigation they'll see in the High Court. Cases that are routinely issued in the High Court for £2,000, £3,000, £4,000. And I get the sense that there's some alarm that this is happening in the classic way that the senior judiciary never expects. When you allow people to bring claims for distress, oddly enough, a lot of claims for distressed people crop up. Well,
this brings us on to another question. How do you quantify distress without a medical report?
Well, you stick your finger in the air, is the short answer. You can look at TLT, and the claimants in that case, I think there was something like 6 or 7 cases. The most significantly distressed claimant received, I think, 12,500. The younger claimants received something like 2.5. There is a case whose name completely escapes me at the moment, but it was a case where mother and daughter has Down syndrome, daughter goes to a primary school in year 5. There's some incident of some nature, and the head, trying to be terribly helpful, writes a letter to all the parents saying, we have this little girl who's got Down syndrome, and she's normally lovely, but sometimes things happen. All our staff are trained, and mum sues the school on behalf of both child and herself, saying this is private information, this is breach of the Data Protection Act, and they receive £1,500 and £2,500. I think mum got £2,500 and the little girl, because she was young, received the lower award. So in essence, you look at comparative cases and try and get a sense of what other claimants have been awarded. It's no different than, thank you, ST, and mine, I know even on primary, thank you. It's no different than looking at comparative cases for personal injury. Although sometimes you have to look at it's not just how distressed you are, because the courts also look at the circumstances of the data breach, and the more egregious the data breach. We think about a case involving the Met Police where they obtained people's the claimants' travel plans entirely disproportionately and unlawfully, and the court, it was on Judge Luber, was very down on the police for the way they went about this. Not that anybody was terribly upset by it, and the court said, well, she probably would have told you the travel plans if you'd asked her. But I think it was a bit of a slap on the wrists for a public body, but look at comparative cases.
Feeding into
and
that
can do some if you want to.
is a claim for distress not amounting to a recognised psychiatric injury deemed a personal injury claim for the purposes of, for example, limitation, quox, CRU?
I would say no, because it's not an injury, is it? It's,
yeah, I agree.
I think it would be. I have never seen it suggested that it's an injury claim for the purposes of quox or anything like that. And it strikes me as artificial to say it is an injury claim, because if you look at the Act, it's specifically talking about distress. Because I think I missed the slide actually, but if you look at what it says in the GDPR, the GDPR talks about material and non-material damage, and the DPA at 168(1) talks about, in the GDPR, non-material damage includes distress. So it's a distinct thing, it seems to me. Yeah. So it's not a 3-year limitation period. Quox doesn't apply, I think. I don't know whether.
I agree. Yeah, I agree entirely. It's like, so it's analogous to, for example, loss of enjoyment, diminution in value in a cross-border claim, or disrepair claim for distress, effectively, for disrepair. So I think that's right, respectfully. Can a claim be made by a claimant regarding information which relates to another party, incorrectly said to relate to the claimant? So I think what's being asked here is where someone has been said to have particular information attached to them, but it's wrong, can you make a claim? So, for example, you might attribute, I don't know, you might attribute a philosophical belief to one person mistakenly, thinking you're attributing it to another.
I think you probably can, because the entire point about, certainly the GDPR, is that data should be accurate. And that is an inaccurate piece of data about someone who's identifiable. So I would say yes. I'd certainly give it a go if I was acting for the claimant.
Yeah, I think by its very nature, that's right, isn't it? The accuracy is one of the parts of it, which suggests that inaccurate information will also give rise to breaches.
Yeah.
Assuming that GDPR applied, would an employer of a seafarer be acting reasonably if it were to pass the seafarer's new salary details to that employee via the ship's master? So in other words, you're telling the ship's master the crew's salary details in circumstances where they could easily have passed them confidentiality to the seafarer directly.
I think that's a breach. I don't think there is any. I mean, they're assuming that assuming there is no other way that these salary details can be passed, which I can't believe in this day and age, and that you have to do it. Well, he's sailing around Malta in circles or something. He might be all right, but I don't see why it's fair or necessary to pass on those details via a third party.
Yeah, it's a lawful purpose, isn't it? Because it's for the purpose of employment, but it isn't fair or transparent or proportionate or necessary.
Well, necessary. And it's fairness that often causes defendants problems, because it's such a sticky little concept. But I can't see why it would be necessary to process the data in that way.
A related question to the one we've just answered: if someone's criminal record has accidentally been attached to the wrong person, can the wrong person claim damages? Yeah, I think they can. But that would come under the, let me have a look, that will come under the other parts of the GDPR that we've not been talking about, under Part 3.
No, well, I'm not entirely sure it would.
Wouldn't it? Because you're looking at conviction.
I have to look at it, how it's arisen, I think. So it might not necessarily be for the purpose of crime prevention. But if you start telling people that, Uncle Tom Cobley's got a conviction for burglary and gross indecency, then and he doesn't, then that is inaccurate data, and I can certainly see why Uncle Tom's going to be distressed by it. So I think that is a viable claim, and good luck defending it.
And related to that, would there also be a claim for misuse of private information? I suppose the private information you're talking about is the conviction, and the misuse is attributing it to the wrong person. But I think that would be quite difficult.
Well, it's not. That's not your private information. I mean, I don't think I can have a reasonable expectation of privacy in relation to data, in relation to information that's not about you, because you never thought about it.
Yeah. And the other person might have a reasonable expectation, but they're not the victim of the tort. So I don't think you've got all the same ingredients in the same person, is the answer to that.
Yeah. I think it's a straight DPA claim.
Gosh, these are difficult questions, aren't they? We've still got more in.
I'm hungry. Go on.
Can a potential claimant insist on knowing the identity and contact details of those who are viewing or examining his or her details, forming the basis of their claim, as a condition of consent to providing clarification or evidence of the claim they are making? So if I make a claim against Richmond Borough Council and I have to hand over my medical records in order to make that claim, can I insist on knowing who is looking at my medical records for the purpose of defending that claim? I think the answer to that is no, you can't.
Yeah, I mean, I think if you give the information out, that is of itself potentially data protection leak for the people whose data, whose emails and names you've provided. I don't see any reason why a claimant needs to know that information. I think all you need to say in those circumstances is that we will comply with the DPA.
Yeah. Yeah.
And that's an end of it. I mean, I probably shouldn't say anything more about people who ask that sort of things, because I'll get in terrible trouble. But
it's
I don't
quite
think
a lot in litigation that anxious claimants say, well, I want to know who's viewing my records, to which the answer is always lawyers who are under professional obligations.
Professional obligations of confidence.
Yeah. Right. Paragraph 133, presumably of Lloyd, states the privacy tort, like other torts for which damages may be awarded without proof of material damage or distress, is a tort involving strict liability for deliberate acts, not a tort based on a want of care. Does that restrict the MPI, misuse public information, private information rather, to only deliberate acts?
Yes, is the short answer. I wrote about this not so long ago, actually. There has to be a misuse, there has to be an act. It can be an unintentional act, but there has to be, you have to do something. And it's important because I think the scope of the tort of MPI and breach of confidence has been misunderstood and conflated with data protection. Data protection legislation is designed to protect the integrity of the data. So if you lose it, if there's a cyber attack, that's what you're looking to vindicate your rights. MPI is about, and breach of confidence is about people deliberately or carelessly using private and confidential information in a way that is inconsistent with the rights and expectations of the claimant. So they are very different, but which is a very long-winded answer, I think, of saying yes, there does have to be some sort of intentional or unintentional use, because it's called misuse. Not, for instance, if you just lose a piece of information. I've got a case at the moment about a police force losing something. That is not, I would argue, MPI or breach of confidence, but it is data protection. Point.
Can the grounds for processing personal data be relied on after the event as a defence? So, for example, if the party completely accidentally disclosed personal data without checking they fulfilled the conditions of processing, but in hindsight could have relied on one of the conditions of processing, can they defend the claim on that basis, despite the fact the initial disclosure was accidental? Can you go back and remedy your breach effectively?
Yeah. My instinct is to say no, because one of the points of the GDPR is to improve compliance with data protection. And when people are processing data, they are meant to be recording the justification. There's meant to be some sort of either tick box form or something that says, well, I'm processing this data because I have your consent or because it's legitimate interest and I've done this balancing exercise. It seems to me to be against the spirit of the GDPR to be able to say, well, actually, we didn't do this properly, but we could have done. I don't think that would help you on breach. I think it would help you on quantum arguments to say, well, actually, all right, hands up, but you can't say you're distressed. You can't say you've suffered any financial loss, because if we had turned our mind to it, we could have done it properly.
So there's no causation.
So you haven't actually suffered any. You can't prove you've suffered a loss. I think it's a very good quantum point. I think it's a less good breach point.
Yeah. There's some guidance by the ICO about this, which seems to suggest that that's right, that you can't go back and unbreach. Lastly, we're seeing an increase in subject access request claims, and due to current working conditions, they're not being dealt with in a timely way. Is a claim for distress due to the delay in dealing with those requests reasonable?
I've had this, actually. I think this is a role. Well, context is important. I think it's a role point. I think the defence is saying, well, look, we've explained to you, assuming that, this is perhaps a generous assumption, assuming that people haven't just completely ignored things, and it's not something terribly important. I think the defendants should be saying, well, we're sorry, but we can't actually see that you've suffered any property. In the 21st century, are we really saying that you're distressed by this? Would a person of reasonable fortitude be distressed? The answer is no. So the threshold is too low to get a claim going. But you can envision a circumstances, I suppose, where something is very important, where the subject who makes the access request really needs information for a particular regulatory reason, or for something very important, or there's been a complete stonewalling. You can see why, where in those circumstances you might get a legitimate distress claim going, but your average, sorry, we just haven't got around to it sort of claim, I think you've got a decent threshold defence.
Related question, I think. How much notice does the court take of how quickly the breach is addressed and rectified when assessing damages?
A lot, in my experience. And it sort of, it goes, I think you go a long way as a defendant when you hold your hands up and say, sorry, this shouldn't have happened. And that obviously feeds into the amount of distress. Because if someone says sorry to you, you'll probably feel that I could be less distressed than if someone says, oh no, I haven't done anything wrong. It's almost like in police cases, you always get the pleading for aggravated exemplary damages saying, well, because you're defending the case, that makes it even worse. So I think it's right that if you are nailed to the mast as a defendant, as it were, there's merit in fessing up and saying sorry.
Well, there always is, isn't there? I'd have thought.
Well, yeah, exactly. I mean, it's just common sense. Don't try and defend the undefendable, because you end up paying more for it in the long run, both in terms of costs and damages. So mea culpa is a good thing, I think.
And then I think probably our last question: what is the liability of the sender of a wrongly directed email, and then disaster, the recipient posts the contents on social media? So it's a sort of Rolf case, except the recipient doesn't just press delete, and the recipient publishes the email. Are you, as the sender, then liable for the recipient's actions? Or is that a novus actus? Does that break the chain of causation?
I suppose it depends what the information is and who the recipients are, and whether it was foreseeable that this would happen. I mean, you're liable for a data breach, certainly. Whether you're, I'm sorry, read the wording of it. If you go back to Article 82, it says any person who has suffered material or non-material damage as a result of this regulation shall have the right to receive compensation. So it is the damage caused by a breach of the regulation. Arguably, yes, but I certainly understand. So, is it an intervening act?
I'd argue it was.
I think it's arguable. I mean, I wouldn't want to die in a ditch on the argument, though. Because, I mean, you are liable. You're going down for something. Quite whether you should go down for all the distress caused by some slightly peculiar person posting something on the internet when they shouldn't be doing it. I suppose you'd have a contribution. There'd be a contribution claim against the person who put up the post. I think that might be your best bet. But in terms of, I'm not saying this without any sense of context, but I think I'd be a bit nervous about running its trial on that argument alone when you've clearly cocked up. But anyway, if you want to give us more information, we will have a think about it and ponder it. But it's a good question.
It's a great question, isn't it? I mean, absolutely fascinating questions, interesting, fun, and we've answered them all so easy as well. I was right from the beginning.
Well done us.
Thank you all for coming. If you've got any more questions for us, then please direct them to Ian, who's obviously in charge of answering questions. Our email addresses are on the screen now. Next time, Paul and Lisa will be discussing material contribution. That's not a Thursday webinar, it's a Monday webinar, but quite a difficult issue. I mean, it puts us to shame, actually, even more difficult than GDPR. Material contribution, but obviously an interesting one for everyone. Thank you very much for coming. We'll let you get on with your day. I'm sorry we've overrun, but so many interesting questions.